A lasting power of attorney, or LPA, is something that gives someone authority to manage another person's affairs while they're alive. But one of the most common questions is, what happens to it when the person dies? Does it carry on? Does it automatically transfer to someone else? Or does it stop completely? So in this video, I'll explain clearly what happens to a lasting power of attorney after death and what takes over instead. And the short answer is this: it stops working as soon as the person dies. A lasting power of attorney is a legal document that allows someone, known as an attorney, to manage another person's affairs while they are still alive. There are two main types, one for financial decisions and one for health and care decisions. It's designed to help when someone loses mental capacity or needs support managing their affairs, but it only applies during their lifetime. At the moment someone dies, the legal authority of the attorney ends immediately. They no longer have any power to deal with bank accounts, property, or any other assets. Even if they were acting under the LPA right up until that point, their authority stops the moment death is confirmed. There's no overlap period where both systems apply. The reason it ends is because the legal framework changes completely after death. While the LPA deals with a living person's affairs, once someone dies, their estate becomes a separate legal entity, and that estate is then managed under probate law, not power of attorney. So the authority shifts from the attorney to the executor or administrator. Once someone has died, the responsibility moves to the executor named in the will. If there is no will, then an administrator is appointed instead. Their role is to apply for probate where required, identify assets and debts, and deal with the estate administration process, so they effectively take over where the attorney role ends. It's a completely separate legal responsibility. A common misunderstanding is that people think an attorney under an LPA can continue managing accounts after death, for example, dealing with banks or paying bills. But once death occurs, any actions taken under the LPA are no longer valid. At that point, banks and institutions will only deal with the executor once probate authority is in place. Now, one question that often comes up is this: can the same person be both an attorney under a lasting power of attorney and also the executor of the will? And the answer is yes, they can be both. There's nothing in law that prevents someone from holding both roles, so in practice it's quite common for a spouse, adult child, or close family member to act as an attorney during someone's lifetime and then later deal with the estate as the executor after death. But what's important to understand is that these are still two completely separate legal roles. So even if the same person is doing both, the authority they are acting under changes the moment death occurs. The LPA stops immediately, and the executor role only begins once probate authority is in place. Another practical question that often comes up is whether an attorney can arrange the funeral. And in most cases, the answer is yes in practice, but it's important to understand how that fits legally. While the LPA itself does not specifically give funeral authority in a legal sense, in reality, attorneys are often the closest person managing affairs right up to the point of death. So it's very common for them to take the lead in organizing funeral arrangements, especially if they are also a family member. However, once death has occurred, they are no longer acting under the LPA when doing this. Funeral arrangements are usually handled by whoever is closest to the deceased, often the executor or next of kin, and the costs are paid from the estate, so it's more of a practical responsibility than a formal legal power under the LPA. There's also another practical point that often causes confusion. Some people think that once a death is registered, all government departments and offices are automatically notified, but that's not quite the case.
The Tell Us Once service is very useful because it does notify many organisations after a death is registered. However, and this is important, it does not notify the Office of the Public Guardian. That means the Office of the Public Guardian will not automatically know that a lasting power of attorney has ended. In practice, it simply stops being valid at the point of death, regardless of notification. But if there is any ongoing administrative requirement, or if documents need to be updated in other contexts, it is still the responsibility of the family or the executor to ensure everything is handled properly. So again, it comes back to this key principle. The LPA ends at death automatically, not through notification. Once the person has died, the attorney's role is very simple. They should stop using the LPA immediately, notify relevant organisations where appropriate, take a copy of the LPA, as HMRC require a copy if an inheritance tax return is necessary, return the original and any copies of the LPA and death certificate to the Office of the Public Guardian so it can be cancelled, and pass responsibility to the executor or family handling the estate. From that point on, they are no longer acting in a legal capacity. Understanding this is important because it prevents mistakes. If someone continues acting under an LPA after death, even with good intentions, those actions may not be legally valid. It also helps families understand clearly who is responsible for what at each stage. So the simplest way to think about it is this. A lasting power of attorney only works while someone is alive. Once they die, it ends immediately, and the executor takes over through probate. If you're dealing with an estate at the moment, understanding how all these roles fit together makes everything much clearer. So I've put together a free Executors checklist that walks through the process step by step. It helps you understand what needs to happen and when. You can download it using the link in the description. And if you'd like clear, practical explanations of probate in England and Wales, feel free to subscribe. I'll continue to break these topics down in a straightforward way.